Welcome back, everyone. My name is Marie Kasprick, and I'm the Executive Director of the Institute of International Economic Law at Georgetown Law. Together with the Graduate Institute Geneva and the Geneva Trade Platform, we have organized today's conference on how to make the WTO fit for future trade. I'm delighted to introduce the next session on the future of the WTO dispute settlement. Once considered the organization's crown jewels, the WTO's dispute settlement has been facing a lot of criticism over the past years. Much in line with the theme of today's conference, how to make the WTO fit for future trade, our next session will be discussing how to make the WTO's dispute settlement function and shine again. At the end of the session, we will be announcing the winners of the hackathon, so stay tuned. I would like to remind everyone that there will be time for Q&A and that you can ask questions to the panel through the Q&A function. With that, I would like to introduce the chair of our next session, Professor Jennifer Hillman. Professor Hillman is a senior fellow working on trade at the Council on Foreign Relations. She is also a professor from practice here at Georgetown Law. Maybe most importantly for this conversation, she is a former member of the WTO's appellate body. So with that, I hand the baton over to you, Jennifer.
Well, thank you very much, Marie. And I want to, again, join everyone in thanking everyone for participating in this, and particularly for the students for participating in the hackathon. I am sure everyone is going to be sitting on the edge of their seats waiting to hear the winner. So do stay tuned. But again, I want to welcome everyone to this third panel, Agreeing on How to Disagree, WTO Dispute Settlement 2.0, focused on where the WTO's dispute settlement system is headed and how it might be fixed in ways that would satisfy a variety of concerns and desires. I think it's pretty clear from this conference and from the hackathon that the World Trade Organization and with it the rules-based system is in deep trouble. And I would argue that the trouble is deepest at the dispute settlement system, where the United States' blockage of appointments to fill vacancies at the WTO appellate body left it as of December 19th without a quorum to decide any new cases, which opened the door to countries avoiding compliance with rulings that they don't like or find difficult to implement. I think during that kind of dark December of 2019, there was some hope for resolution. New Zealand's Ambassador David Walker had been appointed, quote, to seek workable and agreeable solutions to improve the functioning of the appellate body. There was a general hope that countries would not do what was perceived then to be unthinkable, which is appealing cases to a non-existent appellate body. And even back in December of 2019, there was a lot of discussion over use of the Dispute Settlement Understanding's Article 25 to engage in arbitration, at least as a short-term bridge to a fix. And yet here we are, 15 months later, 9 appeals have been filed into the void, 4 by the United States and 1 each by Saudi Arabia, the European Union, Indonesia, Korea, and Pakistan, which may mean that more countries are finding that they like this system where you can block the adoption of a panel report you don't like simply by filing a notice of appeal. And at the same time, there's an awful lot of work that's been done and a lot of sort of meat put on the bones of the idea of a multi-party interim arbitration arrangement, again, as some form of a alternative or bridge to a fix of the WTO. So we've got a lot to discuss to sort of take stock of where we are now and how we might get out of this impasse. And to do that, we have an excellent panel. Ambassador João Machado, who is the European Union's permanent ambassador to the WTO and who has had a distinguished career at the European Commission, having served as the Director General for Maritime Affairs and Fisheries, the Director General for Mobility and Transport, and the Deputy Director for DG Trade. We also have with us Minister Yong Li, who is China's now Minister and Deputy Permanent Representative to the WTO. So congratulations, Minister Li, on assuming that role, who has also had a distinguished career with the Chinese government, having served as the Deputy Director General in MOFCOM's Department of WTO Affairs, as the head of China's WTO ITA expansion team and its environmental goods negotiation team, along with numerous stints along the way, serving as the lead negotiator on investment provisions in China's agreements with New Zealand and ASEAN, and many other things. Thirdly, we have Dr. Jeannie Remy, who comes to us from the Rampal Center for International Trade Law, Policy and Services at the University of the West Indies in Barbados, but who is certainly no stranger to Geneva or trade law circles, having practiced law at Sidley Austin's Geneva office and having served as a legal officer with me, I would add, at the WTO's appellate body. And rounding out our mix, and I love this G2 conference for the mix of sort of academic voices and public service voices is Kathleen Clausen, who is an associate professor at the University of Miami Law School, who previously served as an associate general counsel at the Office of the United States Trade Representative, who again spent a lot of time litigating these cases, so is very well steeped in the processes. She is now really a prolific and highly respected scholar, writing about all aspects of international economic law, dispute settlement and procedures, international security, cybersecurity, and so much more. So if we could, I'd like to start with you, Ambassador Machado. In February, the European Commission published its trade policy review, an open, sustainable, and assertive trade policy. And it included an 18-page annex devoted to reforming the WTO, including its dispute settlement system. For some, and I'm going to put myself in that camp, the document represented a shift a bit for the EU, as it expressly stated on this WTO dispute settlement system that the United States has raised a number of valid concerns about certain adjudicative approaches of the appellate body, as well as about specific rulings in certain cases. So at least to my mind, it was one of the first official or really public documents of the EU saying, yes, a lot of the things that the United States has been saying have some validity to them. Can you tell us sort of where is this annex and the EU's approach likely to take us as we think about serious reform to the WTO's dispute settlement system? Ambassador Machado?
Thank you, Jennifer, and I would like to start by thanking Georgetown University and the great Graduate Institute for the invitation extended to me to participate in this very important panel discussion. I think I would say that the title of the panel, probably we are more now on disagreeing how to agree. That's the way that we are right now. And as you indicated in the beginning, Jennifer, the European Commission issued a trade policy review communication mid-February, and a big part of that review, which covers the overall EU trade policy, not only WTO, but the key plank of that policy for the next coming years, is WTO reform. And that's why that you notice that this annex on WTO is as long as the proper communication on trade policy. And a big part of that WTO reform, of course, involves the restoration of a fully functioning dispute settlement system in the WTO. And for the EU, this should be addressed as a matter of priority. And this is because a fully functioning dispute settlement system is a necessary condition for the security and the predictability of a multilateral trading system. Without it, we risk splitting into a power-based relationship and denying our businesses a secure and predictable trade environment, which is not a good service that we would be doing to our businessmen. Finally, without a fully functioning dispute settlement system, it's very difficult to motivate WTO members to say, let's negotiate new rules. Let's update the rules. If you don't have a system to enforce, it's very difficult to motivate. So it's a great part of our strategy for WTO reform is the reestablishment of a fully functioning dispute settlement system. For us, there is no return to the status quo of ante. or a dispute settlement 1.0. And as you indicated very well, Jennifer, in the beginning, this is the first time that in a Commission document adopted by the whole College of the European Commission, it is recognized that many of the concerns that the United States raised are valid, and that we are ready to work with the US and the rest of the membership, of course, to address these concerns. And we know that the concerns of the United States are also bipartisan and are long-standing. This is not something that appeared only with the previous administration. So the EU agrees that a meaningful reform is necessary. And coming back to the concerns that US have indicated over the years, we now should truly share the view that over the time, and after all, the dispute settlement system has been in operation for 25 years. So in a way, it's normal that after 25 years, you may have a kind of a midlife crisis, and you need to go back to the drawing board and to see what has worked, what has not worked, and how can we repair these. And it's true that over time, the system has lost a bit of focus. The original focus was that it's not to create jurisprudence, it's not a tribunal, but it's a system of arbitration to settle promptly the disputes among members. That's what we are looking here. And the procedures have become much more complex, longer, and increasingly focused on creating jurisprudence. Now, I want to say very clearly that we cannot put all the failures and all these deviations over time on the back of the appellate body or of WTO Secretariat. I mean, my firm conviction is that members were themselves also responsible for these, because members litigated a lot. They put armies of lawyers working on cases. It's enough if you think very complex cases that were brought, like Airbus, Boeing, and it's very difficult indeed, such big cases and complex to solve in 90 days. So you cannot put everything on the back of the appellate body, nor in the back of the WTO Secretariat. That would be unfair. But now we have an opportunity really to go back, review what is not working, and come up with a more streamlined, more effective dispute settlement. I insist on this, in line with the original objectives and the design of the system as in the dispute settlement understanding, the DSU. So a number of ideas that the EU has put in this WTO reform paper. We start by saying we can give some more legal language, more secured language to some of the ideas that are already in the paper that Ambassador Walker, as previous chair of the General Council, came up. But the EU is ready to go further and to look at other ways. But on that regard, we need to work with the whole WTO membership. And in particular, we need to have clarity on what are the US proposals, where the US wants to go. And I understand the new administration and the new USTR is only very recently appointed. But it is important that we have clarity so that we can then together jointly try to address the concerns that US has identified. And in that regard, obviously, it would be most welcome to have clarity from the side of the US as soon as possible. So I want to stress here as well that from the side of the EU, as I said, we are willing to work. For us, it's very important to have the system of arbitration of dispute settlement in the WTO for the reasons I have already indicated. And we really hope that at the ministerial conference that we are going to have, if everything goes right, if the pandemic situation comes under control, that by the end of the year, when we have the ministerial conference 12, MC 12, that ministers could endorse a roadmap putting in place, I insist, a time-limited process to agree on a package of dispute settlement reform. I think it will not be good if the objective is to address the shortcomings that were identified. The idea is not to reopen the DSU and to come with something completely different. As you know, those that are following these questions of dispute settlement for a while, there has been a DSU review with the WTO since 2001, and until this day there has been no outcome of it. We don't want to have a repeat of that exercise. So we need to have a time-bound roadmap with specific instructions and look at ways to repair, to redress, and to make the system again effective with the key objective of having a prompt resolution of disputes among members while ensuring the legitimacy and the quality of the rulings that come out of that system. So I will stop here, but I will be in.
Thank you. Thank you. Minister Lee, if I could ask you, I mean, since joining the WTO in 2001, China has been very active in the dispute settlement system, filing, 21 cases as a complainant, responding in 45 cases, participating as a third party in 188 others. How does China view the prospect for reform and restoration of the dispute settlement system? And does China agree with the EU's assessment that the US has raised valid concerns with the system as it's been operating?
Thank you, Professor Thierman. And first, I would like to thank organizers for having me in today's panel discussion. And actually, AB issue has been discussed for quite a long time, even before its paralysis. It's good that people gradually come to agree that we need to address the concerns raised, especially by US, and we need to reform. But to date, there is no answer to how yet. And in the meantime, consequences of AB paralysis is really obvious and worrisome. And as you mentioned, Jennifer, at the beginning, that since the paralysis, all those panel reports circulated were appeared to the dysfunctional AB, and 3 of them were appeared by US as the respondents. So if one asks WTO members the priorities of WTO to address current challenges, I guess almost all will have AB in their lists. And in most cases, it would be the top 1 in their lists. So looking back in the past of 26 years, we have to say those who have been complainants or respondents more or less have concerns or dissatisfactions with the adjudications. Some even have grave concerns. But to address the concerns and solve the problems, we need frank conversations and substantial and constructive discussions. Otherwise, it will be continued to be the current situation we all see. Panel reports are allowed, AB cannot function, members have no pressure when taking non-compliant measures. No incentives to negotiate new rules is indicated by Ambassador. And with such situations, in the end of the day, WTO will become totally dysfunctional and irrelevant. So that's not the situation we want to see. And to avoid such the worst situation happens for quite a long time, we established principles together with 12 proposals from members are on the table. Majority members have been trying very hard to address those concerns with maximum flexibilities, as we just heard from the ambassador. But up to date, I have to say, no one knows which direction is the right direction to go. and where the finish line is. Because we don't know what the demander exactly wants. Even for those concerns we have heard, which is said to cause the paralysis of AB, it is hard to tell whether it is a problem of dispute settlement rules, or it is purely the implementation problem, or mixed. So we are looking to the demanders' early engagement and constructive and substantial discussions. Otherwise, such a worst situation will continue, which will harm every member and, in the end, multilateral system as a whole. So at this moment, it is hard to say how to fix the AB. However, there are some critical aspects we think it is necessary and important to bear in mind. Number one, the original intention to establish the current dispute settlement system with the AB mechanism established in 1994. To our view, it is still relevant. The dispute settlement system of the WTO should continue to be a central element in providing security and predictability to the multilateral trading system. Number two, two-tier dispute settlement system and the negative consensus rule. These are great achievements compared with dispute settlement mechanism in the GATT era. It directly contributes to the security and predictability of the multilateral trading system. Such a mechanism will ensure that the disputes could be resolved based on rules rather than powers. Without such a mechanism, there will be no possibility for small members like Antigua and Barbuda to have successfully challenged the US. Number three, the independence and impartiality of adjudicators. Members should shield panelists and AB members from outside interference so that disputes could be decided solely on its merits. Number four, the quality of rulings. The sound reasoning of a ruling always plays a central role in positively resolving a dispute. It is especially true for implementing party to comply with the ruling. So I will stop here. Thank you, Jennifer, and I'm happy to come back.
No,
thank you.
Thank you very much. It's always good to have a few of those kind of where the red lines are sort of laid down as we think about where we are going forward. If I can now turn to Jean-Yves Remy. I mean, you've obviously, Jean-Yves, been involved in working with and representing developing countries for many, many years. And at the same time, you've been very much a part of the appellate body system. I mean, how is the breakdown in the dispute settlement system seen in the developing world? What do you see, and what do developing countries, I think, see as a potential way forward?
Thanks, Jennifer, and thanks to the organizers. I don't have much time. We've been confined to 4 minutes. So I think I'll just touch on 3 things to answer your question. One is the overall politics of where we are. And we just heard from the EU that in their EU trade policy, there was certainly a tip to the United States and a clear focus on signaling an intention to engage, acknowledging, as he said, the valid concerns that the US has raised before, and seeking to enshrine the Walker principles, but also being willing to go further in terms of additional legal formulations, whatever that actually means. I think all they're asking for in return is this good faith engagement. So just tracking what they've said in their own sort of policy paper. I think it's interesting to read between the lines what was not said. The EU did not in this sort of formulation seek to reference the MPIA. They didn't explicitly talk about a 2-tier system. Because we know from Washington that there has been some discussion about keeping the system just at the panel level and going a little bit back to the GATT days. and really just highlighting the need at the basic level for automaticity and independence. And I think one of the reactions we heard from at least the former U.S. Ambassador Dennis Shea is that you need to interrogate the EU even further than its good faith efforts in its paper. So asking really how far they've come and questioning really whether they've reconsidered the stance they've taken up until now. So my question, and I think it's hard to put developing countries into one homogeneous unit because they vary: China, South Africa, India, and then small countries, as I think the minister mentioned, even small islands like Antigua and Barbuda, into one homogeneous group. But I think what would be clearly questioned by those who have stood by the EU up to now is sort of how far in that entreaty it's willing to bend to accommodate the U.S. interests, and how far we are in a lack of clarity currently, and waiting in good faith for the U.S. to pronounce itself with the new administration. But I think it must raise concerns, at least those who have sided up till now with the EU's positioning of, how far that breaks from the sort of the line taken in the past, and how much more engagement will they be willing to do on a bilateral basis with the U.S. So questions about fractures within that sort of group based on the EU's sort of entreaties. The second thing that I would sort of mention is what's happening, and Jennifer, you mentioned me being at the Secretariat. I'm sort of very partial to sort of what's actually happening on the ground, whilst all of that broader politics is playing out. I'm told that there's a sense of although when you look at the WTO website, there seems to be a continuation in the rapacity of cases coming out, but at least at the panel level. But I think there's been a sort of a shock in a sense to persons working at the appellate body. This entire stock of expertise has been sort of, abandoned because many of the members working in the Secretariat are no longer there. There is a sense of panels working in a little bit with some futility under the shadow of these appeals into the void, but not only for negative sort of respondents, for the respondent negative cases, but I think also in a case where complainants are not successful, the possibility that these will be withdrawn, these disputes will be withdrawn. So a lot of energy, maybe a sense of potential futility in the system and not really knowing what's going to happen. I think another, point to raise is this unutilized MPIA. So far, from my understanding, there have been 3 or more sort of MPIAs negotiated. 2 have led to sort of some settlement. One is there remains a possibility for a dispute to be brought under the MPIA, but certainly far short of the expectations of the 25 members who have now signed on, still constituting just 1/5 of the overall membership. In fact, less than 1/5 of the membership. There's a sense of a whole lot of expectation that is possibly going to be shut down and met with some disappointment. And I think the MPIA, the idea is not cottoning on to members like India and South Africa, which in their paper, looking at plurilaterals, did not specifically mention the MPIA, but in separate communications have said that this does an injustice to the multilateral consensus basis of the WTO, the WTO wider architecture. So unlikely, I think, that any of this is going to bring any of the membership closer to some kind of solution, if at all, creating even greater fractures. So we're seeing a system that is sort of fragmenting rather than coming together. The last point I would make is sort of the emphasis so far on the Walker principles and on the engagement between membership and the appellate body has sort of left in the dark what we want to do with older questions. Sort of what are we really going to privilege with our selection of judges? What are we going to privilege in terms of the representation and representativeness of the appellate body? And of course, the broader sort of architectural issues have to be sort of faced. But I think towards the end of the appellate body, we were seeing fractures in the appellate body membership. This sense of collegiality had kind of broken down. We have to think, therefore, about differing philosophies of judges occupying these roles at the appellate body, an absence of a shared value and purpose in the method of adjudicating and their view of the role of the court. We have to find ways in whatever new system we carve up to engender this strong sense of collegiality so that collective decision making can still happen, and that sort of that these fractures that we saw towards the end among the judges, among the appellate body members, doesn't happen. And finally, I'd also like to see, I think, with a rebooted system or a reconfigured system, an emphasis on a different skill set in the selection of judges. So not necessarily only experts in trade, but judges, people who have the ability to be independent in their thinking and have the confidence to adjudicate cases, bearing in mind the strictures that will have been sort of forced on them as a result of the Walker process. I think we also need to ensure that judges are equipped to deal with the growing subject matter of the WTO. And I'm not talking just of trade remedies, but also the digital economy, climate change, labor, investment facilitation. These are the new areas. And I think any new system of dispute settlement has to be particularly alive to the growing scope of rules that the WTO is likely to encompass if these plurilaterals go ahead. But it certainly this is where the membership is going in terms of the scope of the rules. So I'll stop there and I'll wait for any questions or further comments from the other members. Thank you.
So, and then last but absolutely certainly not least, I'd like to turn to Kathleen Clausen. And I'll just start by saying, I know you don't speak for the Biden administration or for the United States, but as a former, USTR official and obviously a keen observer and thinker about these issues, I just would like your take on sort of, okay, the United States now got everybody's attention when it blocked the appointments of the appellate body. What should it do with that attention? I mean, what would you advise the Biden administration to do at this point? How do we get out of the morass that we're in right now? Kathleen?
Thanks so much, Jennifer, and thanks to you and Joost and the whole team for the invitation. Also, thanks to Marie and Michael for their organization and support. It's great to be a part of this group, this distinguished panel, and to see so many experts as well in our audience today. As you suggested, Jennifer, in my role as an academic, I want to maybe bring up the conversation to one level higher of generality. And I think in a way that touches on much of what's been said so far. And I would associate myself with a number of the comments also that Jenny was just raising. My view is that despite the progress that's been made and despite the intent to move forward, we had to find some common ground. I'm not sure we've fully confronted the conceptual challenges as to what the WTO is or should be. And that is going to continue to be, in my view, something that's going to inform any process of reform. So I've written about this as four major areas that we could think of as areas of departure. And I think there's still consistent issues today. One is this dilemma of constitution, really, of ideology that is both descriptive and normative. It's central to thinking about what we want the institution to be, what we think it should do. And on that, I think we still have so many disparate views that it would be difficult to move ahead. A second dilemma is one of responsiveness. And we've come a long way, I think, to responding to some of the criticisms that have been raised by many members over the last 20 years. But are we thinking about building a system that will have the ability still to do that in our conversations on reform? A third is a dilemma of politics. I'll just call it politics. And by that, I mean the ability of the institution to allow members to deal with domestic pressures of constituencies in democracies and elsewhere, the intersection of elections and economic pressures. That is something that as we look ahead, we need to bear in mind. And the fourth in my list is one of just, I'll call it of structure. That is internal and external structure as we consider new institutions that have come into the picture, new tools that have come into the picture in the last 25 years. How do we deal with them? And to refer to something Richard Steinberg has said, thinking about WTO members' interests having diverged at the same time that global economic power has become more dispersed. And what is the structure that's going to accommodate that? So I think those four dilemmas continue to loom large as we have these more detailed conversations of individual things that might change, and they make finding a landing zone in this conversation very difficult. I don't need to tell this audience that, of course, this is a big institution with a lot to do, and while we discuss reforms to dispute settlement, we don't do that in a vacuum. Right? As others have said, this is maybe a symptom in dispute settlement issues of some of these larger issues to which a number of us have tried to point. So not much has changed, I think, in those underlying problems. We need to think about these major power struggles, what's happening at home, what we know does not work, both procedural and substantive issues. And then also the constraints or opportunities that are presented by these other tools, FTAs, other types of trade agreements, individual agreements, bilateral agreements, and unilateral and coercive policies that we've seen come into the fore with greater, with sharper focus. So that leads me to sort of end my comments with a set of three questions. But that last point really speaks to, I think, the diffusion we've seen in trade law that we thought perhaps in the 1990s was not going to be the focus, but that's where, especially with our failure to have more negotiating rounds, we need to accommodate those. So let me conclude with these three, what I think are major normative questions that governments should think about as they walk through this dispute settlement reform process and what we want the institution to be and do. The first is to ask, what can or should members be able to do when they face unfair or unreasonable practices by other trading partners that are not covered by the rules? That is, even if we were to change the rules, what happens when things are not covered by the rules? What governs in the absence of rules for practices in which certain states have engaged? Second question, what can members do, or what should they be able to do when they face unfair, unreasonable practices by other trading partners that are covered by the rules, but because of the procedural circumstances, whether they're evidentiary disciplines or otherwise, those practices cannot be effectively addressed through the WTO system. Maybe they can't be proven, but they otherwise cannot be addressed. And thirdly, what can members do when they face trading partners that have and develop institutional structures that the existing or new rules do not accommodate? I think answering those questions would help in making progress on the broader architectural reforms that we're all thinking about. And then the global conversation can turn to not just papering over longstanding concerns, but rebuilding, reinventing, reconceiving, and reimagining the institutions in a way that will curtail the efforts of these aforementioned dilemmas. Thanks, Jennifer.
Well, thank you very much. And thank you, I will say, to all of our panelists. And I will say to the audience, please, feel free to submit your questions in the Q&A. I'm going to start by trying to sort of pull together a lot of what we've heard, because I heard Ambassador Machado really lay out a kind of a roadmap timeline that really has this notion of, okay, we've got to set a roadmap by the end of MC12. We need to be on a path to doing this. I heard Minister Lee sort of really say, okay, there's these 5 kind of sort of principles, if you will, that at least China is saying needs to be part of the system. And at the same time, I'm hearing to some degree from both, from our, I'll say our academics, if you will, a sense of whoa here. We need to go back to sort of really thinking about what is the point of having a rules-based system and therefore having an adjudicatory system? Let's just think first about really sort of what is the scope and the raison d'etre of that rules-based system. And I guess I may come back to you, Ambassador Machado. How do we square that? I mean, again, I think you heard throughout this debate, you heard the former U.S. ambassador to the WTO, Dennis Shea, kept saying repeatedly, before we can talk about how to fix the WTO, we need to have a conversation about why the system went off the rails first. And until and unless there's an answer to that why question, we can't proceed. And the other part of my question is sort of, does reform of the WTO, can it be done one-off, or does it have to be included with broader reforms to the way in which negotiations are conducted, to the way in which decisions are made, to the way in which the Secretariat functions, or could this be done on its own as a separate matter? So, Ambassador Machado, I just would ask you to sort of reflect on both sort of procedurally and substantively, how should we think about this issue?
Well, thank you, Jennifer. I think for us, there are different aspects of the reform of WTO, which we indicate. For example, we need reform on the way the negotiating function is operating. We need reform on the way the WTO is ensuring the supervision of member state policy. So our reform agenda affects the three core functions of the WTO. But I think it will be dangerous to put everything bundled together. I explained. I think the reform of the dispute settlement system should not be linked to these other reforms. We should not forget that we continue to have WTO agreements that are out there, that are key for our business, and they need predictability on the way they are operating globally. So we are not going to engage in decades of soul searching. Where do we go? Where do we like the system? I mean, there are agreements there that need to be enforced. Of course, these agreements, we may identify failures and things that need to be updated to capture much better certain policies that are not reflected, obviously, because when the agreements were designed, the world economy was different and the practices of members were different. So I think we need to carry on each track on its own merit, but it's not going back and start a decades-long exercise of where do we go from here and making linkages. I think would be a recipe for disaster. And in the meantime, countries will look elsewhere. So our position is that we need to have an engagement and discussion on reforming dispute settlement, but this should preferably not be linked to the other reforms. Again, for the reasons I just mentioned, there are agreements existing that need to be implemented and enforced. And the situation that some of you indicated in the previous interventions, we are seeing a lot of appeals into the void. That's not a situation that we want. And I clarify briefly 2 points that young Yves Remy raised. The reason we did not mention in our policy on WTO reform the MPIA is because for us the MPIA is an interim solution, is not the reform of the WTO. The MPIA was simply a way to continue having the benefit of a two-tier system while the reform will be taking place elsewhere. But a group of countries, 25, wanted to continue to benefit from a two-tier system, which I think was good, because at least among these 25, there will be no temptation to appeal into the void. They can go with the disputes until the end. Now, the MPIA has not yet had cases, because the cases, I don't think you are going to judge the success by the number of cases. I mean, frankly, if members can find solution among themselves without going to dispute, so better. But the reason it has not yet started operating is because, you know, the cases are launched, they are in the panel stage, And the MPRA will only enter into operation if the country's participating members decide to appeal. So none of the current disputes among the participants, because the MPRA only operates among the participants, none of the current disputes has reached the stage where a decision has been taken by the parties to go for appeal. That's the only reason. Now, my ex-colleague Dennis Shea spoke a lot about the why question, the why question. Sometimes we had a kind of an impression that it was like a collective mea culpa exercise, like during the times of Inquisition. Let's all put ourselves as, now let's move forward. Let's identify what is missing is a clear position from the US on, and I'm saying this because it's normal, it's the clear position of the US, which direction are we going? For the EU, there are red lines as well, and my colleague from the Chinese delegation, Minister Yi mentioned, we have red lines as well. And first, negative consensus. We don't want to go back to a situation where a country, particularly the losing country, vetoes the adoption of the panels or appellate body report. Secondly, it has to be independent, judged by independent and in a partial matter. And thirdly, the EU is very attached to a two-tier system. And I can dispel that even if it is not mentioned clearly in the policy document, there is no going back to the panels in the GATT system. There is no going back to that. And for a very simple reason, the disputes that are brought today to the WTO and with the breadth of the agreements covered by the WTO, if you think about things of SPS, but not only, they involve very sensitive matters. And you need after, when you are a losing party, you need to go back to your parliaments and to say, sorry, you are the elected persons, but you need to change the laws that you adopted. We can only do that if the system is really legitimate and serious. And with quality cannot be done by a group of well-intentioned ex-diplomats in Geneva making rulings on such things. And I believe in the US is the same thing. You cannot go back to Congress and say, look, you have to change the laws because three guys in Geneva that they do many things, go to cocktail parties and many other things, and they meet sometimes and they make some rulings. And here you have to go back and change. It cannot be done. The legitimacy of the system depends on the quality of the persons that are sitting and the quality of the ruling. So for us,
if I can stop you there, I want to give Kathleen and Genevieve 1 minute each before I turn to Minister Lee to close us out. But the question for sort of 1 minute is, do we have time to do a lot of what you both have described in terms of this more sort of constitutional, fundamental, what are we all here for? Do we have time to resolve that before, in essence, the system breaks down in the absence of a binding dispute settlement system? Because it's clear right now we don't have one if there are this many appeals into the void. And again, is the kind of approach that you're suggesting feasible? And again, I'll give you 1 minute and then I'm going to let Minister Lee close us out. Kathleen?
Thanks, Jennifer. Yeah, I think we need to stop thinking about this in this sort of binary way that is either we're going to need all this time to do a certain thing that is this end perfect goal, because the menu is endless, right? The menu of possible choices here is endless. And while, yes, there are deep problems in dispute settlement, that whole reform process may only be successful if the negotiating function is restored. So we can't really think of these as separate. And there are trade-offs across that menu requiring all sides to bring something to the table. So the concept of linkage that was mentioned earlier, I think that can mean many different things. It doesn't necessarily mean that, I think as suggested, that we have to have this soul-searching conversation over a long period of time. There are just so many moving parts. We need sort of backward-looking views, but we also need forward-looking views, and that is necessary to keep the institution relevant. stop there.
Jenny?
Yeah, I mean, hard to say. I think there are some things on the table that it would be easy or easier to implement once we get some indication from the new U.S. administration of how amenable they are to the Walker Principles, for instance. So I think it will all depend, a lot of it will depend on the signaling we get. I think and I've said this on many other occasions, there's such broader issues that keep getting swept under the carpet, issues relating to access, issues relating to small countries like mine, their actual participation in the system. They haven't been engaged. They still aren't being engaged. They're overrun by other more pressing issues, dispute settlement, and the history they've had with it hasn't been very positive. So I think there needs to be a broader discussion that extends beyond just the U.S. blocking situation. I recognize that that's the most immediate one, but I think built into whatever reform happens has to be a broader engagement with some of these access issues, some of these representativeness issues. And so I think it's not a conversation that can be had between now and MC12. I think it's a broader discussion. There's some stopgap measures that can happen in the immediate term, but there has to be some kind of broader engagement on the issues that I've raised.
Right, I know we'll let Minister Lee have the last word here before we close out and the drum rolls come out to learn who has won the hackathon. So Minister Lee?
Yeah, so with these issues, I said that for organization, surely, well, even we established the WTO in 1995 with the perfect year-round agreements, everyone applaud. It is not perfect. And then after 26 years, and with the development of the whole world and the change of the global big background and also the individual members' domestic situations, we would see more problems and all the more issues we need to address as people, even talking about e-commerce and other new development and also the investment issues and so a lot. So it is obvious that organization like WTO we have to reform and do a lot of to make an update. But coming to this AB, we have to say that it is part of the WTO reform. And actually, if you look at the WTO reform proposal submitted by quite a number of members, you see the concept of the reform is quite broad. They try to put everything in the WTO negotiations, even also those Doha remain issues and also the new issues. They put everything under that big umbrella. But I agree with Ambassador mentioned that they should be on separate track. We cannot put them together and link together. There we could do nothing. And with regard to the AB, it's quite a procedure issue. If that function stopped, then it will affect the whole mechanism of the WTO. So that's why we emphasize that the AB issue should be solved separately and quickly. Yeah, that's it. Thank you.
Well, thank you very much. And I want to thank our panelists because we've heard a lot about the possibility for a roadmap, about where some of the red lines may be around it, and about where this whole debate fits within the bigger, broader picture of the sort of purpose and raison d'etre of the WTO itself and of its dispute settlement system. So my great thanks to all of my panelists. Thank you very much for your thoughts. And I now want to turn things back over to Marie Kasparek from Georgetown Law's Institute of International Economic Law for what I think is probably what is holding everybody on the edge of their seat. So Marie, over to you.
Thank you so much, Jennifer, and thank you also to the panel. I was able to listen to the last part of it. So before I start with a much awaited announcement, I wanted to mention that the full submissions of the finalist teams will be available for everybody to read and watch on the co-host's website in the coming days. Now, it is my distinct pleasure and honor to serve as the jury's messenger and announce the winner of the inaugural G2 Hackathon. As anticipated and in true WTO fashion, it was not an easy feat to come to a consensus. and the finalists really were neck to neck. In assessing all the proposals, we looked at 4 criteria: their creativity, the rigor of the legal analysis and drafting, the feasibility of the proposals and their actionability in today's context, and the clarity of the presentation. These 4 guiding criteria helped us come to the following decision. I will start with the 3rd place. In 3rd place, winning $1,000 is Team Penn Law with their innovative proposal on feminizing financing for trade in Africa, new approaches to systemic challenges. Huge congratulations to Team Penn Law. In 2nd place, winning $2,000 is Team BSOG with a bold and thorough proposal on fossil fuel subsidies reform. Congratulations. Which makes Team Phoenix with the out-of-the-box proposal on ensuring PPE market supply transparency the winners of the inaugural G2 Hackathon. Congratulations to Team Captain Mariana and her team for their remarkable win and $3,000 of prize money. Mariana, team, congratulations. I want to briefly hand over to you to say a few words. Maybe you can remind us of your team members and also maybe just share a few insights on how you actually got to decide on this topic.
Yes, thank you. Thanks to the organizers, the other teams, members of the jury, and attendees. Our team, Nadia, Alex, Kyle, we were working for this, and I have to say it was an intense weekend making an acronym and giving it meaning. And we're very optimistic about making the WTO fit for future trade. And we are happy to contribute now and in the future. Moreover, we're very excited about our proposal, and we hope to see it flourish through the summer until November. We acknowledge that the WTO is going through a critical moment, and that's why we chose Team Phoenix, because it's cyclically regenerating or otherwise reborn. We remain hopeful that the WTO will overcome the current crisis and rise again eventually to allow for further coordination and cooperation in international trade.
Thank you so much. Maybe one of your fellow team members want to say anything to how you got to choose the topic, or if there was something in the hackathon that you actually really, truly enjoyed. I mean, apart from sleepless nights over the weekend.
Yeah, sure. So I can jump in here. Initially, we started the weekend with wanting to reform all of the data flows in the world and take on something even bigger than the e-commerce agreement that's currently being negotiated. And then we realized very quickly that we weren't going to be able to do that in 1,200 words. And so we decided to zoom in through some crazy brainstorming where someone would say a word and another team member would spark a thought, and this would happen throughout Saturday afternoon. And we saw this till the very end, where it was almost deadline and we just made it. And maybe one of the other teammates would like to speak about that.
Yeah, to give you some insight, we completely took over the common room of our university because we got so engaged with this, and we had to be kicked out by a security guard at 11 p.m. And we hadn't filmed our video yet. And we were in the process of doing that, and we had to, in utter panic, film the video in my room with like 15 minutes to go. So from there to here, it's been a journey. I'm glad we made it.
Well, obviously we weren't able to tell, and it was a thorough proposal, and we really enjoyed your whole proposal, the video, the analysis, and we really look forward to keeping engaged on that in the future with you. I'm just checking with Jos and Gabrielle or Dimitri if there's anything that they want to add before I close us out for today.
Perhaps we can give the floor to the other two teams as well, because they did a great job. If they want to add something or tell a story about how they got to their ideas or some of the problems they struggled with, because it was a difficult call, and congrats to all three teams. Fantastic, really innovative.
Well, I can say on behalf of our team that we were thinking about fossil fuel subsidies, and we knew that this was a thing that was discussed, and we told to ourselves, well, I mean, this was in 2009. Why is this done yet? And then we got into the gist of it, and then we started understanding how it must be like in Geneva and WTO, and we really not only learned, but we also got to experience it, and it was really really helpful.
Yeah, and so for us, on behalf of sort of the PENLAW's International Women's Human Rights class, we started off with essentially a gender chapter similar to all the Canadian agreements that are in there, and then we sort of moved from that a little bit more into how we could use technology and sort of the mobile platform as a way to empower women and sort of reduce barriers for small business trade. That was where we sort of moved towards the implementation or easy to implement part of the problem as to how we narrowed it down.
Thank you so much. Again, huge congratulations. This was no small feat. We were blown away by the proposals and by the response to our inaugural hackathon. And I hope we can keep the momentum going and also inspire maybe, others at the WTO level with our energy, with your energy on how to move forward in the following year. So thanks so much again. Thank you, everybody, for your submissions to the jury, to the panelists, and also to the other organizing committees for all their hard work on this. All good things must come to an end. So it's been an absolute pleasure guiding you through today's program. And thank you for joining us to discuss ways of how to make the WTO fit for future trade. I invite all students and other young professionals in the audience to join us over GatherTown, over on GatherTown, for a fun and interactive career networking session. You can use the link in the chat to join the session. And once on GatherTown, please follow the green arrows and join us in the networking space. So with that, thank you so much, and I hope to see you soon on GatherTown. Thank you.